All right, and then that gets me to Tyler Defa.
Your Honor, I believe he's on.
Mr. Defa, are you there? I can see that he's logged in, but Mr. Defa, although you're unmuted, your microphone is not picking up any audio at your end.
Can you hear me?
We can now, yes.
Okay.
All right. How are we going to proceed on this preliminary hearing today?
Your Honor, I've attempted on a few occasions to meet with him. We've been unable to meet, but my understanding is he wants to hold his preliminary hearing today. So if we can verify that, we'll move forward.
All right, Mr. Defa, do you want to move forward with the prelim, or would you like to visit with Mr. Hendricks for a minute?
I think we can move forward.
Okay. Is the state ready to call its first witness?
I am, Your Honor. State calls Officer Trenton Weeks.
All right, let me get Mr. Weeks in, make sure he's into the meeting here. We've just brought Mr. Weeks in as a panelist so he can see us and hear us, and we can see and hear him.
I can hear you and see you for sure.
All right. Deputy Weeks is here. Deputy, I'm going to ask you to please raise your right hand and be sworn to tell the truth. Do you swear that the testimony you will give in this matter now pending before the court will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Mr. Foote, go ahead.
Officer Weeks, could you please state your name and your position for the court?
Yes, Deputy Trenton Weeks. I'm a deputy with the Duchesne County Sheriff's Office.
And on December 30th or 31st of last year, where were you employed at that point in time?
I was employed with the Duchesne County Sheriff's Office.
Okay. And did you receive a call from a Raylene Lamoureux that day?
I did.
And what was the nature of that call?
Raylene was stating that she had a protective order violation from a previous case. She had obtained a protective order, and that the person on that protective order was contacting her.
And did you do any research or look at anything in regards to that protective order?
I did. I found that there was a valid protective order in place, that it was served, and that the protective order stipulated that the parties were not to, the respondent was not to contact the petitioner on that protective order.
Your Honor, can I be allowed to share?
Yes, give me just a moment.
Is this viewable to the court?
I don't see it yet. All right, we're now able to see a document.
Is the one you're looking at entitled Pretrial Protective Order?
Yes.
Okay. Officer, can you see this the document on the screen?
I can. It's small, but I can see it, yes.
You can probably blow it up a little bit bigger, Mr. Foote. There we go.
Yes.
And is that titled protected by this order named Raylene Lamoureux?
Yes.
Your Honor, this item here, this document here is actually filed in back to the criminal case number. Case number 231800190 here in the 8th District Court.
Okay.
And the state would ask the court to take judicial notice of this filing in the court, as well as the next item that was just on the screen.
All right. Any objection to this document?
No, Your Honor.
It's received.
This is the certificate of notification. This is a pretrial protective order, which states in here that it was served by the sheriff's office upon the defendant. There is also an email attached.
All right. I'll receive the exhibit.
Okay. Anyway, simply showing that he was actually served with the document. Officer, what other investigation did you do in regards to this incident?
So I asked Raylene how she knew it was the respondent who was contacting her. She confirmed the phone number and that it had been saved in her phone as a contact for that person. I compared that phone number to the one we had on file, and it was that person. And then I had her send me copies of those messages with the timestamps.
Officer, you look at the document on the screen.
Yeah, it appears to be a witness statement.
And this is a witness statement from Raylene Lamoureux.
It appears to be yes.
Okay. Your Honor, the state would move to introduce this in as exhibit as well.
No objection.
All right. I'll receive that. Let me read it there, Mr. Foote, just a moment. All right.
Officer, in the last sentence of this statement here, Ms. Lamoureux states that she sent you at least 8 messages that were screenshotted by her. Did you receive those messages from her?
I did. I received the screenshots and added them to the X drive.
Okay. Let me show you this. Can you see what's on the screen right now?
I can. It appears to be possibly a social media message. It looks like one of the ones I received from her.
Is this, in fact, one of the messages one of the photos you did receive of screenshots from Ms. Lamoureux?
Yes.
State will move to introduce this screenshot into evidence.
Received.
It's not coming in the right spot. I'll show my other screenshots. Hold on. Is it still just the paper?
Yeah, we're still just seeing her witness statement.
Now, marked on here is Exhibit 4. Can you see that? It's titled Exhibit 4 screenshot.
Yes, I can see that.
Is this also another screenshot you received from her?
Correct.
State will move to introduce this into evidence, Your Honor.
Received.
No.
Oh, stop. Which screenshot are you seeing now? Is it Exhibit 4 or Exhibit 5?
It says 4.
Can you see another document now?
You're not sharing. Yeah, you're not sharing right now. Mr. Foote, if you just want to proceed with testimony, I think it'll be okay if, as to the number of separate communications there were, as long as copies have been produced to the defendant.
They have, Your Honor.
Okay.
Okay. So, officer, I have so in the first two that were presented to you, number 3, which I wonder why that one pops up on there. It's not working at all. The first screenshot that I showed you, I don't know how to produce. It shows 2 communications. When you reviewed the screenshots sent by Ms. Lamoureux, how many separate communications did you see from Mr. Tyler Defay's name to her?
I don't remember the exact number. It was several. It was more than a couple.
Is there something that would refresh your recollection in that regard?
In her statement, she mentions 8.
She said you 8 screenshots. Do you recall in your report if you wrote how many different communications that were sent to you on those screenshots?
I believe I did. I can check that.
Will that help you remember what you wrote by checking your report?
Yes, it would.
Do you recall writing an affidavit in securing a warrant for the arrest of Mr. Defay in this matter?
I do remember writing that, yes.
Do you have access to that affidavit you wrote?
It would take me a minute, but I can go in and look at it, yes.
Can the court see that on my screen, affidavit for arrest warrant?
Yes.
Officer, is this the affidavit for arrest warrant you wrote for Mr. Defay?
It appears to be, yes.
Going through here and looking at the bottom, does that appear to be your signature?
Yes.
And in paragraph 4 on this screen, can you read that to me?
It says, Tyler Defay on 12/30/2023 via messenger sent Raylene 8 menacing messages.
And are those the messages that she took screenshots of and sent to you?
Affirmative, yes.
There is talk in here about other stuff, but those aren't included on these screenshots that she just sent to you on that date, are they?
I don't believe so.
Okay. So based upon the information from Raylene Leroux, you knew of at least 8 different messages sent to Miss Raylene via Messenger or a Messenger app, social media, on or about December 30th or 31st.
Correct.
No further questions, Your Honor.
All right, Mr. Hendricks.
Officer Weeks, in your police report, you stated that Tyler is the subject in an assault on Raylene. Is that the underlying case that you're talking about?
I believe it was. That's the one that she mentioned, and I looked into that case.
Okay, and as of 12/31, you verified that he was the subject of an assault on her?
He was the suspect of a case with her, yes.
And you said you looked into that case. Did Tyler tell you that on November 29th there was a justification hearing in that case?
I did not get to speak with Tyler about this, no.
When you looked into that case, did you see that there had been a justification on 11/29?
I did not. I just saw that there was a case involving the 2 previously.
So you didn't see that there was a justification hearing on 11/29?
I did not.
And you didn't see that there was a dismissal on 12/13 of 2023?
I did not.
Sorry, a dismissal of charges on 12/23, 12/13. Yeah. No further questions.
All right, Mr. Foote, any follow-up to that?
No, Your Honor.
All right. Any other witnesses, Mr. Foote?
No, Your Honor.
Okay, you want to argue the case?
Yes, Your Honor, in this case here, what we have is he sent, according to Ms. Lamrow's witness statement, he sent messages to her in violation of protective order. I know where Clint's coming from in regards to that other case. That is the case that the protective order, the judicial notice of on those issues. That is the same case. And the question is, there was a justification hearing, there was a dismissal of some charges, but the case was not dismissed until after January 9th. And actually, it wasn't to be dismissed, it was to be dismissed and and there was supposed to be a motion to transfer it to the Justice Court, so nothing was dismissed at that time. There were some charges dismissed, but nothing else besides charges. And so the protective order was still in place, and it was violated by the messages that were sent. Those messages, just for the court's information, exhibits 5 through 11, I believe, were also sent to the court's website along with when they were sent to Clint as well.
Your Honor, we understand that at a preliminary hearing, the burden of proof, how it works, and how things are taken in the light most favorable to the state. But in this situation, we've got a justification hearing that happened on 11/29. There was found to be a justified use of force at that time. There's some confusion as to whether there was a straight-up dismissal on the record followed by paperwork later, or as it should have been, probably should have been, is a motion to remand down or to move over to the Justice Court. Regardless, my client had every reason to believe that he had been found in justified in his use of force, and that the pretrial protective order associated with that would have been dismissed at that time. And it was a month later that these allegations of him reaching out occurred.
Okay, what was the case number?
It's 2318-00190. And that is the question in this matter, Your Honor, is the protective order case. So. The state's argument obviously is that the case was not dismissed. Some charges were changed. However, nothing was done in reflection to the protective order. And nothing was talked about in regards at the hearing to changing the protective order or anything else was in the case. That case was eventually refiled in Justice Court, along with a motion to dismiss this matter, the matter in this court.
I guess my only response to that was it was started out as an assault case and turned into a justice court disorderly conduct case. So charges were dismissed. The assault was dismissed.
I think the question it would be, let's see, I ruled that there was a justification, and I think, let me just look that up just a second. So on the date of the justification hearing, looks like the amended information was filed just before or just after the justification hearing.
Right. Grant Charles, I believe, at the end of the justification hearing made a motion. I don't know if he made a motion, but they filed the amended information, amending count 1 to a Class C misdemeanor.
Disorderly conduct.
Correct. And then it was set for a scheduling conference after that on December 11th. I do know there was discussion by Mr. Charles of dismissing the case out of district court and placing it in justice court since it no longer had a Class A misdemeanor.
All right. It's a fairly complicated question because looking at the statute says that if the court does not find the state it's met its burden under the justification statute, that the court shall dismiss the charge with prejudice. So that charge was dismissed with prejudice, or had to have been by statute at the end of the justification hearing, which would have left within minutes. It looks like the state had filed an amended information, and the amended information has a count of disorderly conduct, a Class C misdemeanor, which I guess potentially could have allowed the court to leave a no contact order in place, and the no contact order wasn't ever dismissed by the court formally until we had an order of dismissal with prejudice on January 9th. So I think technically the protective order was still in place.
To bolster that, Your Honor, at least in the minute entry, the state motioned to amend count 1 to a Class C misdemeanor. That motion was granted. So I don't know that there was ever actually a finding of justification, but I can't tell by the minute entry.
Okay. All right. So we had it reduced. We had the charge reduced to a disorderly. The no contact order was not dismissed until January 9th, and so there is probable cause on the 8 messages that were testified to today that the defendant committed the offense, that there was a protective order in place, a no contact order, that he knew of the no contact order, that the no contact order was not dismissed until January 9th, because that's when the case was dismissed, and there is probable cause that he violated that order with regard to 8 messages. And so I'll order the defendant bound over on counts 1 through 8.
Correct. The state was moving to dismiss 9, 10, and 11, Your Honor.
Okay.
We didn't have the evidence for that.
All right. So ordering the bind over, and I'll schedule an arraignment for, let's do an arraignment on December 9th at 10:30 a.m. Okay.
Thank you, Your Honor.
Thank you. Mr. Defa,
Thank
you're
you.
free to go. Thank you.
Thank you.